Good morning, and welcome to Completing the Paycheck Protection Program Application for Forgiveness. My name is Dana O'Donnell, Director of Marketing with Schaeferman Lakeland. Attorney Scott Borsak, who is a partner and chair of the Schaeferman Lakeland Business Department, will be presenting today's program. Before we get started, I want to let everyone know that today's webinar is being recorded and will be emailed to you within 24 hours. It will also be available on our website at schaeferman.com. Should you want a copy of the presentation slides, you can download them from the Handouts tab. Scott will also be taking questions at the end of the presentation, so please submit your questions on the Questions tab, and we will try to get to as many as possible. Let's get started. Scott?
Thank you, Dana. Good morning, everyone. This repeating game show, if you will, of explaining the PPP program as the SBA continues to interpret has been going on now, I think, for about 3 months, but I haven't really been keeping score. And let me just observe before we get started that this is the longest period of time that the SBA has kept to itself. We're going on something like 20 days without any substantial guidance from the SBA on any aspect of the program. So I'm guessing that there's some avalanche of guidance that's going to be coming from the SBA in the not too distant future. This has, of course, allowed for more careful review of the revised applications for forgiveness. And there are 1 or 2 points that I'll make during today's presentation that are clarifications of some things that we've been talking about in prior programs. Sorry, I didn't have the webcam on. Forgive me. I don't know. Some of you might prefer if I didn't have the webcam on. But let's get today's program started. And obviously, we're talking about the Paycheck Protection Program application for forgiveness, and the application had to be revised to account for changes that were made in the program by the Flexibility Act. And just to review some of the bidding here, the Flexibility Act extended the covered period for forgiveness to 24 weeks, but borrowers can still elect the original 8-week period that starts at loan origination. For those loans that were outstanding before June 5th, the repayment period is 2 years, but if borrower and lender agree, that repayment period can be extended to 5 years. New loans entered into force after that date will be repaid over 5-year terms. The proportion of non-payroll to payroll spending is now 40-60. So you can spend up to 40% of your loan if you spend all of it on non-payroll expenses, and 60% has to be on payroll. If you're in the 24-week covered period for spending, then your testing for full-time equivalents and salary maintenance is going to be 24 weeks. If your business is continuing to struggle during this extended 24-week period, it's going to be difficult for you to survive the salary reduction test if you only have 10 weeks essentially of payroll. Remember that the original loan was for 2.5 months of your payroll, which is roughly 10 weeks. And you're now permitted to disregard the loss of full-time equivalents if you're unable to rehire your employees that you had on February 15th, and you can't find suitable replacements by the end of this year, December 31st, or if you're unable to return to business levels that you experienced in February due to government restrictions, and that condition persists through December 31st. And there'll be some industries, some businesses, some parts of the economy that will continue to be plagued by the business downturn. And the places where I think you're going to see the most significant impact are in personal care businesses, hair salons, nail salons, restaurants. Existing restrictions have made it pretty difficult to get back to prior levels of activity. So for those borrowers in those industries where continuing regulation has adversely impacted revenue, uh, what we've been advising borrowers to do is to manage their FTEs to place themselves inside of this safe harbor. To ultimately determine the application of the safe harbor, we're going to have to sweat this out until December 31st. You know, the likelihood that there's going to be a significant change in infection rates and in business activity every day seems to all point to continuing problems for the economy, because infection rates are increasing, hospitalization rates in a number of parts of the country continue to increase, and a number of states have already begun to roll back their opening provisions. I'm sitting in New Jersey, where I'm usually sitting, and even in New Jersey, which today is one of 4 states that is either stable or declining, the governor has rolled back indoor dining, and that has been suspended right now indefinitely. There are a number of other states that are laboring under far greater restrictions. So this potential for there to be continuing adverse impact on business activity persisting through the end of the year no longer seems so remote. So these safe harbors may be of benefit to a number of businesses. The other thing the Flexibility Act did for us was to extend the forgiveness application due date. Generally, it's going to be 10 months from the end of the covered period, and the first payment's not going to be due until a forgiveness decision is communicated to the borrower. So if you submit an application before the date that's 10 months after the end of the covered period, your first payment's going to be suspended until your lender informs you of their decision on forgiveness. The CARES Act contained a provision that required lenders to respond to applications for forgiveness within 60 days. So if both a borrower and a lender took maximum advantage of the time frames, you could be seeing your first payment due 1 year after the end of your covered period. So let's take a look at the revised application for forgiveness, and this is the long form. We're going to take a look at the short form momentarily. And the way you can tell that you're dealing with the right application, as you can see in the second line in the center of this application, it says it was revised June 16th of 2020. And the lower left-hand corner has the version date, which is June of 20 as well. Now, there were maybe 3 or 4 changes that were made to the long form, in addition to taking out all of the instructions and placing that in a separate document. Previously, the application for forgiveness was about 11 pages with instructions. Now we have a 5-page document with 7 pages of instructions, and we also have the EZ form, which some are calling a short form. But what you have here is a long form, and as I've observed a number of times, the form seems to me to be set up somewhat backwards, that you have to build on the back of the form to then carry information over to the front of the form. And one of the things that we'll do in today's presentation is kind of break out the various pages and give you an order or methodology to gather the data that you need for the form. So while the first page of the form had a lot of conclusory information from data analysis, the second page, where the borrower actually signs, has a number of representations and affirmations that we'll go through, but each requiring that the borrower initial in various places and then sign at the bottom. Here in the third page of the application, the Schedule A, we actually get into a number of the computations, but these all draw from other computations that the borrower has to perform, and we'll provide you with some hints on how you might approach doing the computations that are necessary to draw into the schedules in the worksheet. You'll notice here on the fourth page of the application, the worksheet, you'll see that there is space basically for 7 employees. It could be more because the second block is intended for employees who are paid more than $100,000. In a lot of the situations that I've been talking to borrowers, the average number of employees that I've seen is about 20. So the form doesn't provide enough room to allow for borrowers to show all of their work, and most borrowers are going to have to supplement these forms with exhibits and attachments. The last page of the application itself is a demographic information portion where the borrower can indicate whether they're a veteran or not, their gender, and race and ethnicity affiliation. Now, the instructions do say that the information here is optional, and borrowers can choose whether or not they want to submit this application, this form on the application. As I said earlier, the instructions to the application are now separated from the application itself. And here's the first page of the instructions. And again, you'll see center top of the form, revision date of June 16th, and lower left after the form identification, 6/20 as the version date. So you know that you're dealing with the right set of instructions. And unlike the application for forgiveness, which is substantially unchanged from the prior iteration, there is a bit more information in the instructions that didn't appear before, and we'll go through some of the provisions to keep in mind as we've done in prior programs. But this is the first page of your instructions. And as you see, as I page through this, the instructions do provide line-by-line assistance in the preparation of the application itself. And there is additional interpretive data. You'll notice in the bottom half of this page, there's descriptive summaries of costs eligible for forgiveness. The third page of the instructions provide further detail on instructions for the PPP Schedule A. And the last couple of pages of instructions provide some more descriptive material, including some instruction on how to compute salary reduction, both to determine whether you have a salary reduction issue and whether salaries have to be, whether a reduction in salary is going to adversely impact forgiveness. And that continues on the 5th page of the instructions as well. The 6th page of the instructions is just detail on what the borrower has to continue to maintain during the period after the application is submitted, and documents that may have to be presented during the course of the process of reviewing the loan application. This document that I've just paged through is the EZ form. The EZ form, according to the instructions, is only available for certain borrowers. It'll be for borrowers who are self-employed, independent contractors, or sole proprietors, or borrowers who are using the FTE safe harbors of the Flexibility Act. Those who are unable to hire the employees that they had as of February 15th, or those who are unable to return to the level of economic activity that existed on or before February 15th. So if you don't fall into that small borrower or safe harbor situation, you're not going to be able to use the EZ application, and you're going to be required to use the regular application that we just went through. You'll notice from the EZ application that it is quite streamlined, and there's far less information that you have to provide to demonstrate eligibility for the loan. That first page was basically all the data that you're providing. A lot of that information is similar to what you produce in the long form. You have a number of certifications that you're making, same as the long form, and the document is signed. And the last page of the application is the demographic information that's provided. So a couple of observations about the application. As I said a couple times in other programs, it looks to me like the application is like an erector set, and it's important to have a strong foundation. You're going to build on that foundation to be able to complete the entire form, which is why I've suggested that it's important to start at the right place. And I think the right place to start is wages that are paid to employees during the first quarter of the year. As I've noted a few times, I think this form is constructed backwards. It asks for the conclusions before it demonstrates entitlement. And I think what we need to do is to compile our data, do our analysis, and work almost backwards from the way the application is presented. I think for a number of borrowers, there's not enough room on the form to proceed. And as a result, most forms are going to have to be heavily supplemented in order to get all of the information into the lenders that they need to secure forgiveness. I think that the borrowers are going to have to perform a number of computations that may not be apparent, and by just looking at the form quickly, it's not entirely clear that employers are being asked to make these computations and determinations on an employee-by-employee basis. I know that a lot of borrowers were looking for shortcuts and ways of dealing with the application, and have assumed that they can look at total compensation across their entire enterprise, and so long as their total payroll cost was at least 75% of their Q1 cost, that they'd be in compliance. As we'll see from the application when we take a deeper dive, the level of testing is far more granular than that. And as I pointed out, the EZ form has limited application. It's for the sole proprietors, independent contractors, or those with FTE reductions under the safe harbors of the Flexibility Act. So very limited application of that shortcut form. So diving back into the long form, there's a couple things that I'd like to point out. Um, First is that the ability to use the easy form is highlighted here, and you're expected to use either one of the forms, but obviously not both. And if you fall into the basket of one eligible for the easy form, you certainly ought to use it. The application asks you for employees at the time of the loan, as well as the employees at the time of the forgiveness application. And here they're talking about employees and not full-time equivalents. So just keep that in mind, that it seems that these questions are geared to headcounts per capita. How many individuals do you have, rather than full-time equivalents? The application also requires you to identify your EIDL status. If you applied for an economic income disaster loan and you got a grant, you not only have to identify the amount of the grant, you also have to provide your application, your application number. And remember that if you got an EIDL grant, that grant will reduce the amount of your loan forgiveness. So if you got a $100,000 loan and a $10,000 EIDL grant, and the grants are not loans themselves, they are, as the name suggests, free money that's you don't have to account for. You've received, in effect, $110,000. Even if you spend the $100,000 on the PPP loan correctly, you'll only be forgiven for $90,000, and this is the government's way of recapturing the benefit of the EIDL grant. You'll also have to select the box that corresponds to your payroll schedule, identifying whether you pay weekly, bi-weekly, semi-monthly, or monthly. And you'll also have to identify your covered period. And by now, those of you who have spent some time looking at the PPP program, you know that there's something called an alternative covered payroll period, which allows individuals whose payrolls are every 2 weeks or more frequently the opportunity to align their payroll schedule with their covered period. So if the loan originated during the course of a payroll period, such a borrower who paid weekly or every 2 weeks, but not semi-monthly, could elect the alternative payroll covered period. The period would start at the beginning of the payroll period immediately after the loan originated, and then run for the next 56 days. And if you elect the alternative payroll covered period, then you're also using that same time frame for payment of your non-payroll costs and for testing purposes for your FTEs and salary reduction. Some particulars on the alternative payroll covered period. It's an option for the borrowers. We already talked about it being every 2 weeks or more frequently. It links the covered period to your payroll cycle. Start date we've already covered. The same period is used for payroll costs and to test FTEs and salary reduction. The worksheet, which appears on the 4th page of the application, is really the start of the computations that borrowers are required to perform. As I noted earlier, there's limited space on this, space for 7 employees, plus those who are getting more than $100,000. And we have to identify the cash compensation paid to each of the employees during the covered period, their average full-time equivalents, and obviously to determine the full-time equivalents, we have to look at the hours that they spent in each of the 24 or 8 weeks if a borrower elects the 8-week covered period. But you've got to determine the average FTE over the entire covered period. And then you have to test for salary reduction. And all of this is set out as just a number to be entered. Well, in each of these categories, cash compensation, FTE, and salary reduction, there's a certain amount of data that you have to acquire and in some cases analyze and manipulate. And obviously none of that is apparent from this worksheet. And what many borrowers are going to have to do is rely on a spreadsheet to go ahead and make these computations. Excuse me. One of the interesting parts of working at home, there are phones everywhere. In the second box on the worksheet, we identify the employees whose salaries are over $100,000 a year. We set out the amount of cash that they each receive, and we make a determination of their average FTEs. And the reason we segregate them is that because for salary reduction test purposes, employees who are compensated over $100,000 a year aren't tested in salary reduction, but they are tested for FTEs. So later on this form, we join back the employees from Table 1 and Table 2 for purposes of testing our FTEs, but not for salary reduction. So the bottom part of Schedule A has us manipulating numbers gathered from the rest of this form. So step 1 has us totaling up our average FTEs, not during the covered period, but for the period from February 15th, 2020 to April 26th, 2020, our first testing period to determine whether we have an FTE problem during the covered period. This is one of those instances where nothing on the forms suggests to you how to do this or why you're doing it, and is something, given the length of the period, that's probably easiest handled on a spreadsheet. Again, in step 2, the borrowers need to determine FTEs for the pay period that includes February 15th. That's our secondary testing number. So we're going to look, if you recall, in determining whether or not we have FTE compliance during the covered period, you're comparing the covered period to February 15, 2020 to April 26, 2020. And if you're going to use the FTE mulligan, you're only required to hire back to the February 15th number. So in step 2, we determine what that February 15th number is. Your third step is to compute the amount of the FTE reduction. Did you experience an FTE reduction in the February 15th to April 26th period? If you did, have you hit the February 15th number in the covered period? If not, you're going to have to rehire some individuals, but you now have until December 31st to come up to FTE compliance. So if on either of those 2 tests you come up short, you can't submit your application until you get your FTEs back in line, or you get to December 31st. So what I've gathered here are some of the tools you might find helpful in completing the application. The first is to analyze the compensation per pay period in the first quarter of 2020. And what I've done here is just assumed a semi-monthly payroll 3 months in the quarter, so there are 6 pay periods. Identify all the employees and set out their compensation, total the amount, and then come up with a weekly compensation average, basically just divided by 13. And those weekly numbers are what we're going to use to test whether we're paying employees in the covered period at least 75% of their first quarter payroll. So then once you've done your analysis for the first quarter, you then have to put your 8-week covered period if you're 8 weeks, or this chart's much wider if you go 24 weeks, basically 3 times this width. You have to make a determination of the payroll paid during the covered period. And here again, populating by employee, by week, determining total compensation, average compensation, comparing that to the first quarter average, and now I'm in the yellow field to the right, and the percentage change from the average compensation in the spending period to the first quarter average. And you'll notice for all the employees but one, the one that's conveniently highlighted in red, the percentage changes are all higher than 75%, meaning that the employees have received more than 75% of their Q1 average, with the exception of one who was at 74%. So then what I've done in the last chart is restated all the employees and drawn information from the first 2 tables above, where we set out the total compensation, the average, the first quarter average. We stated the percentage, the total compensation that the employee should have received if they were getting paid at 100% during the covered period, and what 75% of that compensation would have been. We know we have one employee who comes up short, and the deficiency for that one employee is $146. So if I did nothing else, I would have this issue with that employee of $146 to contend with as a reduction in forgiveness. Some of the safe harbor mulligans. Here we're looking at compensation each week, and remember that if salary during that period from February 15th to April 26th is lower than it was at the start of the period, that we can fix that, and that fix is to adjust the employee's rate to at least what it was on February 15th. And if we do that, we don't face a reduction for the salary of that individual. Now, earlier I had mentioned about the time to reconsider certain points, and I think on the salary reduction, there may be some better wisdom, and we'll talk about that in a moment. On the FTEs, you literally have to do the same kind of granular analysis. The period to look at the FTEs is the first 2 months of 2020, or a 4.5-month period from 2019 that starts on February 15th and runs through the end of June of 2019. But to keep things simple, we'll just look at the 8-week period that starts January 1 of 2020 and runs to February 29 of 2020. So we look at those 8 weeks by employee. How many hours did each employee work? What's the average number of hours the employee worked and then determine the number of FTEs. And this chart was prepared under the assumption that 35 hours was a full-time equivalent. It's obviously 40 hours, so I have many more partial FTEs than what's being shown here. The 9.5 is probably off by 7/10, and I apologize for that. But you literally have to get that granular in making the determination. And then you have to look to the hours worked per week from February 15th to April 26th to determine whether during the covered period you've got a target to hit, because the Mulligan test requires you to say that if the reduction has to occur between February 15th and April 25th. So now we're looking to see what my average FTEs were in that period of time. And then we need to compare what were my February 15th hours, my February 15th FTEs, the average hours and average FTEs to determine if I'm short anywhere. My February 15th FTEs were 9.55, which is roughly rounded to 9.6. My average FTEs 9, so I've got to hire basically half an FTE to get into compliance with the FTE calculation. Schedule A, third page of the application, now starts drawing the various information from the charts that we prepared and carries from the worksheet. So line 1 draws the worksheet box 1, line 2 the worksheet box 2, line 3 comes from box 3 on the worksheet, and we're literally just copying numbers at this point. The cash compensation, line 4, not surprisingly, box 4 of our worksheet, and the average FTEs, box 5, comes from the worksheet, box 5. Non-cash compensation paid during the covered period. All of this is coming from payroll reports. The total amount paid or incurred for employee health insurance, paid or incurred for employee retirement plans, and the amount paid or incurred for state and local taxes assessed on employee compensation, are all coming from a payroll report, and you can lift the total numbers right off the report and drop them onto these lines. Line 9 looks for owner-employee payroll, which again is drawn from your payroll reports. And line 10 here is the sum of all the items that you identified on this worksheet. The full-time equivalency calculations, there's a box here in the second line of that section that if you had no reduction in employees or average paid hours, you check the box and proceed into the next portion of the application. You're also asked here if you're going to be using any of the FTE reduction safe harbors from the Flexibility Act, either your inability to hire employees by December 31st, or a reduction in economic activity because of compliance with governmental regulations, whether it's standards for sanitation, social distancing, or other worker or safety requirements. And if you're in that situation, you're going to check that box. But again, if you could check that box, you would be on the short form instead of this long form. So it looks like there was some disconnect in the preparation of the EZ form and this long form. I'm not sure this last area is something that you necessarily needed, but it's here. You have to make a determination of the average FTEs during the reference period that you chose, one being the first 2 months of 2020, the other being the 4.5 months of 2019. But whatever the average FTEs are, that goes in line 11. Line 12, you're going to bring back your FTEs for individuals who are paid over 100,000 and add those to the FTEs making under 100,000 to have your total number of FTEs. And then you're asked to divide the reference period FTEs by your covered period FTEs to determine if there was any sort of reduction. And at line 13, the SBA refers to that as a reduction quotient. So if you had more FTEs on February 15th than you do during the covered period, and you don't choose to remedy that, or during that period that begins on the 15th of February and goes to April 26th, that's going to affect this reduction quotient. And elsewhere on the form, you generate some impact. So now that you've done a host of calculations, you're probably ready to start populating the first page of the application with information. If the borrower had a loan of over 2 million, or the borrower and its affiliates had an aggregate loan over 2 million, you're going to check this box. Remember, the reason you're checking the box is that the SBA had quite a row in the beginning of the program with who was actually borrowing. There was quite a bit of hand-wringing over whether certain borrowers should have gotten loans, whether they were eligible for loans in the first place. There were questions about whether the SBA was going to prosecute borrowers for making false oaths or participating in the program when they shouldn't have. And as the SBA began to understand the magnitude of the problem, they ultimately decided that for borrowers whose loans were under 2 million, or borrowers and their affiliates with loans under 2 million, they weren't going to ask any questions about whether the borrower was eligible for the loan in the first place. And if the loan was over $2 million, the SBA reserved the right to audit whether the loan was necessary. For those whose loans are over $2 million, if the SBA on audit determines that the borrower should not have received the loan, so long as the borrower pays back the loan, there's no penalty and there are still no questions asked. So the only implication to checking the box for a borrower with loans over $2 million is if the borrower cannot repay the loan and the loan was determined to be outside the bona fides of the program. So long as a borrower has the ability to repay the loan, there's not any question here about checking this box. So now we're drawing information in from other parts of the application. Going to take the payroll costs from Schedule A. In lines 2, 3, and 4, borrower is going to insert their non-payroll costs, mortgage interest, business rent or lease payments, and utility payments. Information on FTE and salary wage reduction is going to be drawn from other parts of the application. The total salary is going to come from the worksheet, box 3, and lines 6 and 7 are calculations drawn from other parts of the application. The potential forgiveness amounts, line 8 is a calculation based on information that you put on this page. 9 is your loan amount, which also appears at the top of this page. And line 10, we're asked to take the payroll and divide that by, divide the payroll by 0.6 to come up with a payroll limitation. But the curious part about this is that payroll isn't limited to 60%. The part that's limited is the non-payroll expenses, which can't be more than 40% of the total spend. But SBA here wants to test the payroll portion. And then for line 11, you take the smallest of lines 8, 9, and 10. Again, I can't see how 60% of the payroll cost is the maximum amount of forgiveness. But this is the SBA's approach. This is one area where I think there might be some reconsideration on this form. Second page of the application, providing some instructions, does have a couple of interesting points I'd like to highlight. This box I've marked at the bottom, eligible non-payroll costs must be paid during the covered period or incurred during the covered period and paid on or before the next regular billing date, even if the date is after the end of the covered period. So this is all tied to the question of paid or incurred. And I've heard a lot of comments about the somewhat generous application the SBA has provided to non-payroll costs as applying to payroll as well. And I just would like to highlight a couple of the differences in the choice of language here. So first, the SBA is very specifically talking about non-payroll costs being paid during the covered period or incurred during the covered period and paid before the next regular billing cycle. In the paragraph above, where they're talking about payroll costs, the SBA says that payroll costs that are eligible for forgiveness are those that are paid and incurred during the 24-week or 8-week period. So that's very different than the paid or incurred, which comes into the discussion for non-payroll costs only. The SBA has provided some specific guidance and an example, just drawing this out further. So the guidance talks about in a covered period that starts June 1 and goes to July 26. So obviously, this is an 8-week covered period. But in revisions to guidance that came out after the Flexibility Act, they changed this example to a 24-week period, but the principle still holds. They talk about a utility bill paid on June 2nd for the period prior to the covered period, a utility bill paid on July 2nd for June, and a utility bill paid on August 2nd for July. And note the August 2nd date is outside of the 56-day or 8-week covered period. The guidance allowed the June 2nd bill and the July 2nd bill and 26 days of August. And the reason they allowed the June 2nd bill was that it was paid during the covered period. The July bill was paid and incurred, covered the June period, and the August bill had 26 days in the covered period, and because it was paid immediately after the end of the covered period, they allowed that as well. So there's more than 56 days of covered period payments here, and there was no mention in the guidance that this notion also applies to payroll expenses as well. So the instructions and the guidance both seem to dovetail completely in that there is more flexibility in the time period for non-payroll expenses than there is for payroll expenses. And one of the reasons suggested for this was that the 40% limitation on non-payroll would limit any abuse of this. I don't think this is even much of a consideration because in a 24-week covered period and a loan of basically 10 weeks of payroll, there's really no way a borrower is going to be able to pay 24 weeks of non-payroll expenses and 24 weeks of payroll expenses, all from the government loan. So most borrowers are going to be using all of their loan, forget about substantially all, but probably all of their loan in a 24-week covered period to pay payroll to make sure they get up to 60% spend. So this page of the application, the second page, requires the borrower to make certain certifications and representations. The borrower needs to represent that the funds can only be used for authorized purposes, that all the documentation that was provided is true, accurate, and correct, that if the borrower makes a false statement, that those false statements are punishable by law. Tax documents that were provided were all correct and accurate. And for a borrower that checked the FTE safe harbor, FTE reduction safe harbor, that the borrower was unable either to hire employees or that they are still functioning at diminished business activity, and this form is signed. So those certifications, funds only being used for authorized purposes, everything's accurate, didn't knowingly make a false claim, tax returns are consistent with what was actually filed, and if you're relying on an FTE exception, that the exceptions were true. You also have to acknowledge that the SBA may ask for additional information. The SBA does provide some detail in some of the computational requirements on FTE and salary reduction fixes, or what we've called mulligans. So in the box I've just highlighted, the instructions ask us to do a couple of things. One is to determine what 25% of wage reduction would look like. And it specifically has us compute what our target has to be for salary. Now, when I first started doing these programs, I was pretty much convinced that in order to satisfy the salary reduction mulligan, what a borrower had to do was to restore their employee's wage rate to what existed on February 15th, and pay the employee back wages. In looking at the instructions to the forgiveness application, it appears that what the SBA is telling us is that all that a borrower has to do to avoid a reduction in the amount of forgiveness is to return the employee to the salary rate that existed on February 15th. And where I'm going with this is this last area on the second page of those calculations that I just showed you. Here, the SBA asks us to enter the average annual salary or hourly rate as of the earlier of December 31st and the date this application is submitted. And if this amount is equal or greater than the amount on February 15th, the salary reduction safe harbor is met. So if the annual rate for a salaried employee on February 15th is $70,000 a year, and by December 31st, that employee is back to $70,000 a year, then as to this employee, we would have satisfied the salary reduction safe harbor. So the salary deficiency, the amount by which I don't pay the employee, is relevant only to reduce the amount of forgiveness. If we increase the compensation rate by that Mulligan date, now December 31st, there's no penalty on account of the reduction. But if you haven't spent those dollars that otherwise would have gone to this employee, you can't get forgiveness for that amount because forgiveness is based on what you actually spend. So if you restore the employee to where they were on February 15th, you're not going to suffer, it appears, a reduction in spending eligible for forgiveness. But if you have money left over that would have gone to that employee, you can't claim forgiveness for that. This will only work for you if you have spent all of the loan proceeds on eligible expenses. Page 6 of the instructions now goes through a number of the documents that the SBA wants you to gather and have available: bank statements, tax forms, payment receipts, canceled checks. For purposes of FTE, the borrower's got to put together the schedule, which handles a computation of average FTEs on February 15th, and they still talk about June. Oh, I'm sorry, the two periods, February 15, 2019 and June 30, as well as the first 2 months of 2020. In addition to doing all of these computations and gathering all of these documents and providing them with the application for forgiveness, the borrower has to essentially keep their work. The computations that they did to back up everything on the various tables all has to be maintained. So however the borrower made their computations for salary and wage reduction, the compensation of each employee, documentation as to the offers and refusals of employees to come back to work, particularly if you're claiming a safe harbor. the documents that demonstrate the level of business activity before February 15th, as well as after the 15th and through the end of December of 2020. And once again, more demographic information, the same as we saw in the short form. And I'll just say again, this is optional. So there's quite a bit in this application, and in the 60 minutes that we've spent kind of blazing through this very quickly, what I've tried to do is show some of the interconnections between the forms that the SBA has provided to us, tried to draw out some of the information and computations that have to be made based on the instructions that are provided. And the only way I think the average borrower is going to get through this is with some knowledge of spreadsheets. Otherwise, this is a lot of manual rote calculations that could easily be handled by a well-designed spreadsheet. Dana, do you have one or two questions for me?
I do. I'm sure I have more than one or two, but I'll just pick a few. If you decide to use the 24-week period and exhaust funds in week 12, are you obligated to maintain staff for the full 24 weeks?
The short answer is yes. So if you're using the 24-week covered period and you run out of money in the 12th week and your business can't support maintaining salaries, you do face a problem. You have until December 31st to rectify the problem. And the way you rectify it is by having, by satisfying your FTE requirements by the 31st and having everybody up to the same salary that they were at on February 15th. And, you know, those two fixes ought to remedy your inability to continue paying employees during the covered period, or your inability to keep them on staff. But if you're unable to bring them back to salary by the end of the year, and you're unable to maintain headcount, you're going to have a problem on forgiveness.
If we plan to spend 100% of the loan on payroll, does that raise a red flag? Should we try to spend some of the money on utilities, rent, etc.?
No. No, there's no problem if you spend it all on payroll. The chief purpose of the payroll protection program, or Paycheck protection program, was to ensure that employees would be paid. So if you used 100% of the loan to pay employees, SBA is not going to complain, and there's no prohibition in either the CARES Act or the Flexibility Act to prevent that. The only limitation is you can't spend more than 40% on non-payroll costs.
At what point should we apply for forgiveness to our bank?
I think the answer to that question depends. If you've elected the 8-week covered period and you have no problem with FTE and salary reduction, I would apply immediately after the covered period. The same would apply for someone on a 24-week covered period. If you have a salary reduction issue or you have an FTE issue, you can't apply for forgiveness until December 31st, because you have to demonstrate that you've remedied the FTE and salary reduction problems. Now, theoretically, I suppose you could put in the application after the end of the covered period, but before December 31st, if you brought your staff back to their February 15 rate and you've hired back enough employees to make your February 15th FTE. Because both the guidance and the application look to test on the day the application is filed. But if you file the application before the end of the covered period and you haven't brought your staff back, the SBA is going to presume that you couldn't pay them for the balance of the covered period, and there's going to be a penalty. And because you didn't hold the application back until you could demonstrate that you eliminated the FTE issue and rectified the rate issue, the amount eligible for forgiveness is going to be reduced by what the SBA calls the FTE reduction quotient.
We're in the theater business, and New York is not opening Broadway until 2021. We cannot do the same level of work as before and cannot bring up our FTEs. What documentation do we need to provide to get forgiveness?
Well, if you're in the theater business and Broadway is dark until 2021, I wonder what you're spending the loan proceeds on. I mean, I suppose you could spend it on rent if you actually own a theater, but you've got a 40% limitation. You have to spend 60% on payroll. You could certainly pay employees, so the payment of payroll through your payroll provider is all fairly well documented. The rent payments are also documented by check and a lease. The problem is that once this PPP money runs out, I'm sorry. Once that money runs out, you have nothing to pay the employees with, whether you've gotten to the end of the covered period or not. We know that there's still not going to be any revenue in theater operations because they're all closed. For a business that's not going to operate until 2021, that isn't taking in enough money and can't remedy salary reduction and FTE by December 31st, I don't see how you get complete forgiveness for the loan. And a borrower in that circumstance who hasn't spent anything yet might think twice about spending it because they're going to have to repay it.
Can you use the EASY application if you cannot rehire the same number of employees that you had in February because social distancing is not possible in your workspace?
Well, that's kind of a conflation of the two Flexibility Act safe harbors. The inability to hire employees is not limited by any set of facts. So it looks to whether there's any reason, put that aside, whatever the reason is that you're unable to hire the employees, through December 31st, you would be eligible for that safe harbor. The social distancing and other government regulations is tied to the level of business activity. So you need to pick one basket or the other. the employee inability to hire employees by December 31st, I think might be harder to demonstrate. But that's all going to be a facts and circumstances basis, specific to an individual borrower's situation. How about one more, Dana?
Sure. Do owners who receive W-2 salary count towards FTEs?
Yes, they do. For purposes of FTE, the owner looks like anybody else. So I'd like to thank you all for attending today's program. As I said earlier, my expectation is that the SBA is sitting on a bunch more guidance that will be coming out over the next several weeks, possibly months. As we've done before, we'll be sending out email blasts to our attendees, letting them know that there is information of interest out there. We'll summarize that in the blast, and we'll provide a link to our website where you can read more about whatever it is the SBA has done. We'll continue to do programs as there is information to convey, and I continue to be available to answer a question or two, as well as to provide legal services to those who need assistance in navigating this minefield. Stay safe, everyone, and I'm sure we'll be speaking again soon. Have a good day.